My name is Beth Ann Childs, and I am an attorney who represents Oklahoma cities and towns. One of the biggest challenges facing municipal attorneys is ensuring that elected officials stay in compliance with the Open Meeting Act. As you know, violation of the Act is a crime. Failure to comply can also have civil consequences, not only for the elected officials, but also for the cities and towns that they serve. The Open Meeting Act is codified in 25 OS sections 301 through 314. The statute expressly provides that it is the public policy of the state of Oklahoma to encourage and facilitate an informed citizenry's understanding of the governmental processes and governmental problems. This should serve as the basis for all advice that you give pertaining to the Act. All meetings of public bodies must be held at specified times and places which are convenient and open to the public. This is a provision that may be overlooked by those planning the locations for public meetings. As a matter of course, public meetings should be held in a place that can be easily accessible. If meetings are held in facilities that do not enable those with disabilities to attend, public bodies need to make accommodations to allow not only attendance, but meaningful participation. In other words, if persons with disabilities can access the building, but not the room where the meeting is held, then public officials need to take steps to address this situation, such as relocating the meeting to an accessible space or budgeting for upgrades that are in compliance with the Americans with Disabilities Act. The Open Meeting Act also provides that advance public notice specifying the time and place of the meetings must be provided. When I review agendas, I always ensure that the date, time, and place are prominently displayed. Additionally, if the meeting is being held in a facility with multiple rooms, it is prudent to identify the space where the meeting will take place. For example, if the meeting will take place in the City Council chambers, then the agenda should reflect that location. Identification of the room where public meetings will take place is not something that appears to have been litigated. However, because violation has civil and criminal implications, it is always better to be safe than sorry. A source of considerable discussion by the courts involves identification of the subject matter or matters to be considered at the meeting. For elected and appointed officials, it is sometimes tempting to say less rather than more about items to be discussed, particularly if the matter is likely to be controversial or negative. It is never a good idea to be vague about matters on the agenda, regardless of the actual or perceived public reaction. This issue was discussed at length in the case of Wilson versus City of Tecumseh. In Wilson, David Johnson was employed as city manager of the City of Tecumseh and manager of the Tecumseh Utility Authority. Following a municipal election resulting in a turnover of 3 council seats, Mr. Johnson submitted his resignation. Prior to the new council members taking office, there were several items on the agenda. These included executive sessions to discuss Mr. Johnson's employment, including action items as well as consideration of his resignation. Following executive session, the council voted to authorize a $30,000 payment to Mr. Johnson, which was intended to serve as a bonus. Several months after this action took place, 12 taxpayers filed a qui tam notice threatening suit if the city did not take action to recover the money from Mr. Johnson. Litigation ensued, with various motions considered by the trial court. The court held that a majority of the city council members knew in advance of the meeting that a bonus would be considered, but took no action to notify the public of this proposed action. The court specifically noted that reasonable minds could not differ that the agendas were deceptively vague and likely to mislead. As such, this action was taken in violation of the Open Meeting Act, and the ruling of the trial court was upheld by the Court of Civil Appeals. Citing Andrews versus Independent School District number 29 of Cleveland County, the court reminded the parties that the act serves to inform the citizenry of governmental problems and processes by informing them of the business the government will be conducting. Advance notice to the public via agendas must be worded in plain language, directly stating the purpose of the meeting, and the language used should be simple, direct, and comprehensible to a person of ordinary education and intelligence. Review of all agendas for public bodies should be conducted with the tenets of these cases in mind. There are basically 4 types of meetings of municipal public bodies that are provided for in the Act: a regularly scheduled meeting, a special meeting, an emergency meeting, and a continued reconvened regular meeting. While these may seem self-explanatory, municipal attorneys should carefully review state statutes, case law, and attorney general opinions to appreciate all of the nuances inherent in interpretation. Meeting is defined in the Act as the conduct of business of a public body by a majority of its members being personally together. It does not include informal gatherings of a majority of the members of the public body when no business of the public body is discussed. I generally recommend that attorneys for public bodies be hypersensitive to informal gatherings of a majority of their members. Elected officials are regularly invited to attend receptions, parties, training sessions, and other types of events. In my experience, conversations between elected officials generally tend to drift towards matters that are of importance to the public body. Even if they do not, the appearance of these types of informal conversations can be problematic in the event of a challenge. Care should be taken to avoid these types of situations. For example, I routinely advise my elected officials of the provisions of the law and ask the clerk to be mindful of any events that require posting. The Act defines regularly scheduled meeting as a meeting in which the regular business of the public body is conducted. All public bodies are required to give notice in writing by December 15th of each calendar year of the schedule showing the date, time, and place of the regularly scheduled meetings for the following calendar year. The notices for cities and towns and public trusts that have municipalities as the beneficiary must be provided to the municipal clerk. Public bodies handle notification in different ways. Some pass resolutions and others simply approve the written schedule. Either way, it is important that the public body take action and provide not just the dates, but also the time and place of the regularly scheduled meetings. It is also important to ensure that the public trusts are providing notice to the city or town clerk. If the trustees do not also serve as the elected officials for the public body, and if the city or town clerk does not provide administrative support, this notification may be overlooked. This is particularly true if the attorney representing the trust is not a typical municipal practitioner. Importantly, any change made to the date, time, or place of regularly scheduled meetings must be provided in writing to the municipal clerk no less than 10 days prior to the implementation of the change. This particular provision can create confusion for elected and appointed officials. Ideally, the schedule of regular meetings would take into account any required modifications such as holidays, occasions when elected officials will be attending conferences and other events. However, that is not always possible. Proposed revisions to the schedule of regular meetings should be handled as soon as possible and in advance of the 10-day requirement. If that is not practicable, I generally recommend that any proposed meeting be handled as a special meeting with advance notification to avoid running afoul of the 10-day requirement.